Judgment in the matter of the Director of Public Prosecutions against Chris Durham and 2 others.
Lady Carr will explain the decision of the court.
This appeal concerns the circumstances in which it is appropriate for the civil courts to intervene by way of judicial review in a prosecutorial decision to bring or to continue criminal proceedings. The appellant is the Director of Public Prosecutions for the Republic of Trinidad and Tobago. The DPP has powers to bring, continue or discontinue criminal proceedings in respect of any offence against the law of Trinidad and Tobago. On the 21st of April 2009, 3 men were shot and killed in Diego Martin, a town in Trinidad and Tobago. The DPP brought criminal charges against the respondents for the murder of the 3 men. A conviction for murder in Trinidad and Tobago carries the death penalty. Central to the DPP's case was evidence given by a Mr. O'Neill Benjamin. In sworn evidence in 2009, Mr. Benjamin claimed to have been an eyewitness to the shootings. He claimed to have heard the gunshots and to have seen the respondents, whom he knew, with firearms near to where the shootings had taken place at the relevant time. Mr. Benjamin was the sole eyewitness. His evidence was described as, on its face, quote, cogent, unquote. However, shortly before the start of the trial in 2019, Mr. Benjamin was said to have told the prosecuting attorneys in a pre-trial witness briefing that his earlier evidence had in fact not been true, albeit that he was said to have indicated that he nevertheless intended to repeat it at trial. The prosecuting attorneys made the trial judge and the defence attorneys aware that they had serious concerns about the continuation of the trial. The DPP also disclosed notes recording Mr. Benjamin's discussion with the prosecuting attorneys to the defence attorneys. The DPP did not discontinue the prosecution. On the 23rd of May 2019, days before the criminal trial was due to resume, and a jury having already been impanelled, the respondents brought an urgent claim in the civil courts for judicial review of the DPP's failure to discontinue the prosecution. The High Court granted leave on a without notice urgent basis and, following a full hearing, granted a declaration that the failure to discontinue was, quote, unreasonable, improper and unfair, end quote. The indictment setting out the charges against the respondents was quashed. A majority of the Court of Appeal, Chief Justice Archie and Rajkumar Justice of Appeal, upheld the High Court's decision, with Barrow Justice of Appeal dissenting. The DPP now appeals to the Judicial Committee of the Privy Council. For reasons given in the judgment that we are handing down, the Board unanimously allows the DPP's appeal. The Board holds, firstly, that leave to seek judicial review should not have been granted, and secondly, even if it had been appropriate to bring a judicial review of the DPP's decision, the majority in the Court of Appeal was wrong to find that there were exceptional circumstances that justified quashing the DPP's decision. Judicial review is a remedy of last resort. It is not generally appropriate to pursue such a challenge where there is a suitable alternative remedy. The Court needs to consider whether any of the complaints raised could not be resolved adequately within the criminal process itself. Whilst judicial review of a prosecutorial decision is available in principle, it is a, quote, highly exceptional remedy, unquote. There are limited circumstances where this threshold may be met, for example, where there has been bad faith or dishonesty. There are good reasons for such a restrictive approach, including the fact that the DPP's powers are conferred in very broad and non-prescriptive terms, the polycentric character of official decision-making, the delay caused to the criminal trial by judicial review proceedings, and the need to avoid undermining prosecutorial effectiveness. It is within neither the constitutional function nor the practical competence of the courts to assess the merits of such decision-making. Applying these principles, leave to seek judicial review should not have been granted in this case. The criminal process provided the respondents with an alternative remedy that was not only adequate, but far more appropriate to address the issues arising out of any conflict in Mr. Benjamin's evidence. The criminal proceedings were already up and running, and the next hearing fixed for only 6 working days away. The judge in the criminal proceedings would have been much better placed to address issues relating to potential abuse and unfairness. There were multiple safeguards within the criminal proceedings that would have served to ensure justice for the respondents. The board points in particular to the following features: the duties imposed on the prosecutor, defence and the judge, the ability to make an application to stay the proceedings and/or make a submission of no case to answer, the respondent's ability both to call the prosecuting attorneys to give evidence and the ability to attack Mr. Benjamin's credibility by reference to what he was recorded as having said in the pre-trial briefing. See in particular Sections 6 and 15H of the Evidence Act, the ability to make closing speeches to the jury, the judge's directions to the jury, and any appeal if necessary. The respondent's further argument, alleging that the statutory nature of the right to seek judicial review in Trinidad and Tobago is more constitutionally powerful, does not challenge this conclusion. In any event, even if a judicial review challenge had been appropriate, the majority of the Court of Appeal were wrong to uphold the quashing of the DPP's decision on the grounds of irrationality and abuse of process. As to irrationality, the DPP was under no obligation to provide reasons for the decision to continue with the prosecutions, meaning that the respondents could not rely on his failure to do so as a basis for their challenge. It was also important to bear in mind that Mr. Benjamin had put forward 2 conflicting versions of events. It was not for the courts on judicial review to assess or determine which version of events was true. The High Court and the majority of the Court of Appeal erred when they appeared to accept that the version of events put forward by Mr. Benjamin in 2019, as opposed to 2009, was true. It is questionable whether the issue around Mr. Benjamin's conflicting testimony fell neatly within considerations of abuse of process. However, if it did, neither of the 2 categories of abuse of process are made out. Category 1 abuse arises in cases where it will be impossible to give the accused a fair trial. For the reasons given, this type of abuse was not made out, and a fair trial was possible. Category 2 abuse arises where it offends the court's sense of justice and propriety to be asked to try the accused in the particular circumstances of the case. This assessment involves considering whether there has been prosecutorial misconduct, and if so, whether the misconduct justifies staying the proceedings. Again, this type of abuse was not made out. There was no prosecutorial misconduct. Rather, the prosecuting attorneys acted commendably when faced with Mr. Benjamin's comments in 2019, and the DPP subsequently disclosed the notes of the discussion with Mr. Benjamin to the defence attorneys. In summary, there were no circumstances meeting the high threshold of exceptionality, such as to justify the quashing of the indictment. In conclusion, this appeal arises out of an unfortunate sequence of events, commencing with the seeking and granting of leave to apply for judicial review on a without notice basis. The board agrees with the decision of the minority that leave to apply for judicial review should not have been sought or granted at all, let alone in the absence of the DPP. The criminal trial was due to restart within days and provided an adequate and effective alternative remedy for the respondents. It is important for the courts to guard against the danger of unjustified collateral attacks on prosecutorial decisions. As the authorities confirm, occasions when it is appropriate to judicially review a prosecutorial decision, whether to continue to prosecute, are extremely rare. In the present case, there was unwarranted interference by a civil court of concurrent jurisdiction with ongoing proceedings in a criminal court. For all these reasons, the Board allows the appeal. It will be for the DPP to decide what, if any, next steps are appropriate.
The court will adjourn.